Hi guys, AJ here coming at you with some more IP, and this week, welcome to week 5, we will be looking at passing off, some extensions to the action for passing off, the misleading or deceptive conduct provisions in the Australian Competition and Consumer Act, and also the restraints of trade that are covered in the Australian Competition and Consumer Act. First up, in relation to passing off. So last week we were talking about trademarks, trademark registration, the action for infringement of a registered trademark. I mentioned at the end of that video that the action for passing off can be quite useful in situations where the mark itself has not been registered, or where there are difficulties in proving infringement. So if you have a look at section 120 of the Trademarks Act 1995, it says a person will infringe a registered trademark if the person uses as a trademark a sign that is substantially identical with, deceptively similar to, the registered trademark in relation to goods or services in respect of which that trademark is registered. So what I want to draw your attention to here is the phrase uses as a trademark. Now that provision is a little bit special, a little bit unique. There is no corresponding provision to that particular phrase in the UK or US legislation. So here we have the UK legislation, and in section 10.1 you'll see a person infringes a trademark, registered mark, if they use in the course of trade a sign which blah 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 is identical with the registered mark. So there's no actual requirement that you can see here of use as a trademark in the course of trade, unlike our legislation. Okay, so where you can't show that there has been use of a mark as a trademark, you're going to run up against problems with your infringement action. And this is where you may find it useful to turn to the action for passing off. So in terms of passing off, broader sweep than just a trademark infringement action, you need to show your reputation that you have laboured hard and long at generating. It'll be sufficient to prove goodwill. There's no actual need to show that the average consumer would identify the source. It's enough that there is goodwill and reputation attached to whatever mark it is that you're using.
I'd say happier than a camel on Wednesday.
Get happy, get Geico.
And interestingly, and I'll hark back to this in just a minute, it can be sufficient that the reputation has been generated not just by yourself, but by other people out in the marketplace, by the consumers, by general use of language, okay?
You know, I feel like the Target brand makes better quality products.
Then you need a misrepresentation, and the misrepresentation can be generated in any one of a countless number of ways.
You sit on a throne of lies.
But essentially that misrepresentation will suggest some kind of connection between the person that's making the misrepresentation and the goods or services that are bound up with the goodwill, the reputation that is being sought to be protected. Okay, usually that misrepresentation will suggest some kind of sponsorship, of affiliation, approval, or whatever, or it'll be a case of the goods actually masquerading as the original proprietor's goods, trying to free ride off of that original trader's hard work in generating their reputation in the marketplace. And that free riding element is really what this action is designed to prevent. And finally, there has to be damage or a likelihood of damage to the original proprietor that developed the goodwill or the reputation. Interestingly, given that Australia has no publicity rights like the United States, the passing off action has been used by some celebrities with varying degrees of success to try and protect either their image or their famous poses or activities and so forth. You'll see that Fitzgerald and Eliades refer to the Henderson case, a famous dancing couple that were able to restrain use of their image under the action of passing off. However, there was also an equally publicised case by a well-known athlete called Gary Honey. Qantas used his image in some prominent advertisements, and he was unsuccessful in the action for passing off against them. It was held that the use of his image merely suggested general laudatory properties like, excellence in sport and so on. And he failed dismally in using this particular action to try and control use of his image.
That's gotta hurt.
And so some hits, some misses in using this particular action for celebrity control of their visage and their image. There has been some further developments in the action of passing off, and here they're principally around the whole issue of domain names, and particularly where you've now got the action for reverse passing off. So where a domain name's been registered, for example, to attract consumers to that particular website because they think that website's going to be affiliated with somebody or some mark that's quite famous. And then the website contains information or content that potentially can damage the owner of the famous name or mark that's represented in the domain name.
Hey now, don't look at this.
I put up a link to a case that bears some of that reverse passing off kind of hallmarks in relation to domain names. The other issue in relation to domain names revolves around the whole requirement in passing off that there be not just a reputation but a misrepresentation that ultimately leads to damage. And the BT against 1 in a million case way back in 1998 is still the principal case dealing with that whole issue. And at the time it caused rather a stir. I remember I was in the UK at the time, and it's a UK case. People being very up in arms about the perceived extension to the reach of the action for passing off, and people were rather worried that it might lead to a small avalanche of case law around the passing off requirements. But it hasn't really led to any great disruption. The BT case really has just provided a rather useful augmentation to the general principles for passing off. And what happened there was you had a rather, I was going to say sneaky, perhaps calculating business trader that registered a whole heap of domain names, and those domain names were associated with very famous British companies. So you had BT, British Telecom.
Nothing at all.
It's not what you call all the rage, is it?
British Telecom. It's you we answer to.
You had Ladbrokes, which is a very famous UK betting agency, rather like our TAB. You had Sainsbury's, which is kind of the equivalent of our Woolworths or Coles.
Sing it to me now. I will be cooking all night.
You had Marks and Spencer's, which is a very famous department store over there. All of these names were registered by the defendant as domain names, and there was no actual active website that was placed up for any of those registrations. So they were just merely dormant registrations on the Internet Domain Names Register. And the question there was whether or not the court could conclude that there had in fact been a case of passing off, given that there was just merely this dormant registration for all of these different names. The way the court got around that issue, I think, is eminently sensible, and it got to the right conclusion. The way that they injuncted the defendant from using those internet domain names and ultimately had them, I believe, transferred over, was they said that by registering those internet domain names and using those famous marks, because of the similarity in the names registered with those famous marks, it would either inherently lead to passing off if those domain names were ever actually used, so active sites placed up, either inherently lead to passing off, or on the other hand, those internet domain names had been registered to enable passing off. They were adapted to be used for passing off, and they were likely to be used fraudulently. Okay, as such, it was considered that the registration of those domain names, those names that suggested those famous British companies, was essentially equipping the defendant with what they called an instrument of fraud.
You're a fraud.
And the court held that it was more than able to injunct against the defendant using those instruments of fraud. So there is a little extension of, or sidearm to, the whole issue of passing off, rather interestingly, in the digital environment. Just as a footnote, it was actually held that there was passing off in the traditional sense, even though there was no active sites associated with those domain name registrations. It was held that merely the act of getting those names onto the register, and those names being inherently very similar to, or exactly the same as, those famous British marks, was sufficient to make a misrepresentation to anybody that consulted the Internet Domain Names Register, and therefore passing off was established. Now, they also did a bit of fancy footwork around the whole issue of whether or not there could have been trademark infringement. They noted the fact that there was some debate in the UK about whether an infringement action required use of a mark as a trademark. They said, even if we do require use as a trademark, we think that there has been a threat, a sufficient threat to infringe by registering these names, and therefore we would injunct in that situation anyway. So a very interesting little case, as I said, in the digital environment, very early, but still very useful in terms of the way it's kind of evolved the whole notion of passing off. In terms of the ease of this action, let's not beat about the bush. And obviously, it's going to be much easier to pursue someone for infringement of a registered trademark. There are a whole stack of provisions in the Trademarks Act that assist the registered trademark owner in pursuing infringers. And one of the big things one of the big ticket items for registering a trademark is that you don't have to go ahead and prove your reputation. And this is where the action for passing off can be quite difficult to mount for someone that might perhaps have difficulty showing sufficient reputation in their mark. So if you're only a new trader, or if you trade in a very limited geographic area, it may well be difficult to succeed in your action for passing off because of that evidentiary burden of having to show a sufficient reputation, and a reputation that's geographically big enough to cover the defendant's purported wrongful misrepresentation. So much like the whole action for breach of confidence, that equitable action, really the tort of passing off is your fallback option if and when, you know, your action for trademark infringement kind of falls away or runs up against some other blockage. Like I said, you know, you can't show trademark use, then you might find it useful. However, in that situation, you'll usually find that even if an action for passing off is mounted, you will have somewhere in the pleadings an action for misleading or deceptive conduct under the Australian Consumer Law, the ACL. And I realise this video's already hit the 15+ minute mark, so we'll leave it here for part 1. And for the next exciting instalment, part 2, see the next video that I'll post up in relation to the ACL. Thanks. Bye, guys.